Yeah, and now Professor Kaminskiene from another point of view with involved person. So advocates or attorneys at law in mediation.
Well, hello everybody, dear colleagues. Thank you for introduction. I'm not only professor at Mykolas Romeris University, I'm also advocate. That's why perhaps I have a right to talk about advocates and lawyers. So, first of all, I would like to say my biggest congratulations to Riga University and the whole team who organized that marvelous event, because you've got a wonderful atmosphere here and very interesting presentations. Also, I would like to thank moderator for very proficient moderating. That is always a big challenge, as I know, as the same like for mediators sometimes. And I have to say that I have two challenges to cope with. The one is that I'm between you and your lunch break. So that's a big challenge for me. I have to be short and brief. And the second one is that it is always risky to speak about advocates. I believe that it's better to speak in a good way about them or not to speak at all. But I will try to do that as long as I'm advocate, so I can criticize myself also. Okay, let's do that. As one of previous presenters from Lithuania said, mediation in Lithuania had a very tough road for last 10 years. And I was searching for a mountain to show you, and I've chosen this one, rather tricky, very tough in the very beginning, and right now we feel like we are doing some progress. And yes, we are going forward, but what's the reason that we are so slow? We have relatively short history of peaceful settlement in Lithuanian courts. 20 years ago, I would say that our judges were very suspicious about peaceful treaties. They believed they have to find out material truth and to say who is right and who is wrong, but not to help people to look for peaceful settlements. Even in administrative courts, sometimes you know what it is. As long as majority is here lawyers, administrative courts solve disputes with public authorities, tax cases. So sometimes when disputants in administrative courts wanted to conclude a peaceful treaty, they were directed to the courts of general jurisdiction to confirm this kind of contract. So that was even like a no-sense. Then litigious society, of course, but I would like to illustrate it with the numbers. Only 2% of all cases in 2015 in the courts of first instance in Lithuania were finished with the peaceful treaties. So that it's really few, enormously small number. And every time, of course, we know lack of funding, lack of information, but all the time we make conferences, projects on mediation in Lithuania, we face the same critics, that one of the biggest problems is litigation-oriented and mediation-opposed lawyers, advocates. So that's the thing I'm speaking about today. So, is that true? Because one thing is to speak badly about lawyers, advocates, and another thing is to check, to make survey about that. So that was our task. So this presentation is not only of mine, this is together with my colleague, because we made a survey in 2015 with advocates. How do they look at mediation? Because I need, like a scientific person, proof. Do they really hate mediation, or they are hesitating, or they could become fans of mediation. So, first of all, we wanted to check the legal regulation. What's about that? Maybe something is wrong there. But if we take a brief look, we see that advocates in Lithuania, they have the right to be mediators and to participate in mediation from 2005. So it's more than 10 years. They can do that freely. New code of bar ethics, it was enacted a couple of weeks ago. Advocates are prohibited to provoke groundless litigation in Lithuania and are obliged to foster the clients to solve disputes peacefully. So everything with legal regulation is okay. And let's then see, are they mediating? So list of court mediators of Lithuania. So we have right now 154 of them listed, and 26 of them are advocates or assistants to advocates. So I would say all prerequisitions for advocates' positive look on the mediation are present. We have them. But let's take a look what survey showed us. First of all, we organized that survey during general meeting of all advocates. I'm sure you have the same thing in Latvia when people, advocates from all over the country come and meet each other. So we had a table with the slogan, let's solve disputes peacefully. And some advocates were approaching us and saying, oh, great, you do perfect things, we are very enthusiastic about mediation and peaceful dispute resolutions. But the others, they were coming and saying, you want to steal money from us, it's not fair. So we had very contradictory situation in which we had to make that survey. And we managed to make survey to get responses from 354 advocates. So it was half of those who were participating in the general meeting. And what are our findings? So first of all, Lithuanian advocates, and I would say that results can be a bit closed, maybe perhaps with Latvian advocates, because we are brothers and sisters. So Lithuanian advocates, they believe that they know what mediation is. They even believe that they know that advocate can behave and can act as mediator, but in practice they say that we practice mediation or try mediation very rarely. So nevertheless, they have knowledge and they have understanding of mediation, they still are hesitating to use it. Then we asked the question, would Lithuanian advocates recommend mediation for their clients? And yes, was answered by half of the advocates. And the other half, I would say, was saying either no, I wouldn't recommend, or they said, I don't know, so they were hesitating. So they are still waiting for something to happen to recommend mediation for their clients. What about the numbers? Number of mediations performed by these advocates that were surveyed. It was 275 cases during 1 year period before the survey. So we counted the average, and it was 1.3 mediation for these advocates, this amount of advocates. So it's very low. And then we asked the question, do you charge money for mediation services if you mediate? And then again, only 1/3 of advocates said that, yes, we ask our clients, the parties, to pay money. That can bring us to two conclusions. First one, advocates, they don't treat mediation services as legal services. They don't believe in them so much that they could charge money for them. And second conclusion could be made, that they still have no experience how to do that. That's why they take these first mediations as lessons to get that experience. That's why they believe that it's not possible to charge money. What else? Male advocates have more practice in mediation than women do. That means, again, that women are a bit more hesitating if it's useful. Nevertheless, that we had presentation today that women are more cooperative oriented, but still here men take the lead if they have something new and they want to try it. So men prove that they are more active in using mediation. When we asked why you use mediation, of course, the answers were quite obvious. One advocate believes that they can provide new services for the clients. Either they are just representing the client in mediation, or second one, yellow one, they consult both parties as neutral consultants, and third variant is advocate mediators. Some of them, they said, yes, we believe in future, maybe not now, but we will be able to earn additional income. And the thirds, nevertheless, that it sounds naive, but they believe that I want to make something good for society, for my client, so they believe it's socially valuable services. But the list of reasons they don't use mediation was bigger. First of all, advocates feel that they are not necessary in mediation. Very often we hear in Lithuania that mediators are saying either me or advocate. So they believe that advocates should be out of the mediation session, out of the mediation room. That is wrong, and our courts in Lithuania, we've got recommendations from Norwegian courts. And one of these recommendations on mediation was use mediation in disputes where the parties are represented by the lawyers. That means that if lawyers are present, that it's much easier to commence mediation. But in our practice, with different culture, it's hardly working. This recommendation is hardly working. Second, litigation-oriented education of lawyers. Lawyers in Lithuania are educated as combative lawyers, and we are making changes. We should make changes in this educational syllabus. Not clear rules of professional behavior for advocates acting in mediation, because we have general rules of ethics where it's written that advocates should be loyal to his or her client, but it's not written how he should behave in mediation procedure, where if he or she is too active to defend his client, it can harm mediation. So this lawyer should a bit shape his activity towards neutrality, and that contradicts the ethics of advocates. Different clients and society expectation of advocate profession, because society expects from the advocate to defend, to fight for the rights of the clients. And when advocate behaves differently, that raises questions. And sometimes clients are even writing claims against this kind of behavior of advocates. And finally, the last but not the least, a threat to the source of financial well-being. Especially that is important for those advocates who are working not in the capital of Lithuania, but in province. So proposals, what can be done to challenge these problems? First of all, of course, change the focus of legal education from litigation to choosing optimal dispute resolution procedure. Second, mediation training for advocates, but not general ones as we do usually for lawyers or for other people. It should be clear what advocate has to do, what is his role and influence into mediation process. Third, active involvement of advocates in mediation. We believe that as much advocates are coming into that list of mediators, the better are possibilities that they can get fund of mediation. That's why the doors are open, should be open for advocates to become mediators and mediate. And finally, introduce set of rules of professional behavior for advocates in mediation so they could be sure what they can do, what is ethical professionally and what is not ethically. So that is my presentation. Thank you so much for your attention.
So as here's a lot of advocates, I think we get an inspiration to work more towards mediation with our clients. So we are now ready for lunch. But after lunch, so as I mentioned, we have two very great workshops. One is about ethics in mediation. This workshop will be here in this room. And the other workshop is with Jacques Salzer, just across this room, number 322. I'm sorry, so it's not just across, it's a little bit more to the window side, about the critical moments and difficult situations in mediation. So you had already a little insight about the roots. Yes, we wait you back at 2:30, and after the discussions, back here in the big room to close our beautiful conference. Thank you.